But the case, in fact, presents a very difficult situation for her. If we pursue it, and because of tens of thousands of people who have contributed to support this case, we have the means to pursue it. And if we do, that's going to mean that she and her friends and associates have to testify about Jeffrey Epstein.
Good to have you. Welcome to Public Media Affairs. So this is what just happened. Michael Wolff just flipped the entire dynamic of his legal battle with Melania Trump. He stopped defending and started threatening, walking in front of a camera to outline exactly how he intends to drag her and everyone she has ever confided in into a deposition room. The phrase he used, that what emerges under oath will be painfully revealing, is not hyperbole.
And in fact, we've also asked the court to authorize discovery, which would allow us to obtain all of the documentary evidence, including her prenuptial agreement, that would show that, in fact, she is a citizen of New York. Melania Trump has every reason to want this lawsuit to go away and not to have to answer the obvious questions about her marriage and about Jeffrey Epstein. But unlike most other Trump lawsuits,
it is a mission statement from a man who has interviewed Jeffrey Epstein on the record, who has sat in rooms with the people who populated that world, and who now has a federal court backing his right to conduct formal discovery. Melania's legal machine started this fight. Wolff is now telling them exactly what opening that door is going to cost. To understand why this moment feels like the lighting of a fuse that cannot be extinguished,
I've gotten hundreds of calls over the past few days from the international press, all asking what my lawsuit against Melania Trump has to do with her very strange performance the other day. To be clear, I don't know. Her announcement is as confounding to me as to anyone. But to back up, my lawsuit is in federal court in front of a judge who today, tomorrow, a month from now, the timing is entirely in the judge's hands, will decide on Melania Trump's motion to, of course, dismiss the case.
You must first look at the single most devastating document request Wolff has placed on the table. A request that has been under-discussed by most analysts, but which represents the nuclear key to the entire venue and residency battle. Michael Wolff is demanding access to Melania Trump's prenuptial agreement. The legal reasoning he has articulated is surgically precise and procedurally brilliant.
They are moving to have it shifted to Florida, where the laws are more advantageous and where they maintain Melania is actually a citizen, a Florida citizen. We have countered and offered evidence that she actually lives and spends all of her time and has built her life in New York, and therefore is a New York citizen. And in fact, we've also asked the court to authorize discovery, which would allow us to obtain all of the documentary evidence, including her prenuptial agreement, that would show that, in fact, she is a citizen of New York.
He needs to demonstrate that Melania is by legal definition a citizen and permanent resident of New York. The entire architecture of her legal team's strategy has been constructed around fleeing New York jurisdiction and relocating this fight to Florida, a forum where anti-SLAPP protections are weaker and the judicial bench might be more ideologically sympathetic to a Trump. If Wolff can produce a prenuptial agreement, typically executed with explicit declarations of domicile, that lists Melania as a New York resident, her legal team's argument collapses instantly. The Florida escape hatch slams shut, and she is trapped fighting this war in the exact court system she has been desperately trying to flee. But the legal purpose, the stated purpose, is merely the polite paperwork covering for a much deeper and more explosive reality. Melania Trump's prenuptial agreement is one of the most obsessively guarded private documents in the history of modern American celebrity politics. It has survived decades of tabloid scrutiny, multiple presidential campaigns, countless tell-all books, and the relentless grinding appetite of the internet without ever seeing the light of day. The reason it has been kept sealed in a vault of silence is obvious to anyone with even a passing understanding of what a financial contract negotiated between Melania Knaus and Donald Trump in the social ecosystem of late 1990s New York might actually contain. It would not just be a dry recitation of asset division percentages. It would be a window into the private power dynamics of a relationship that both parties have spent enormous energy insulating from direct examination. It would detail the financial architecture of the marriage, the understandings, the concessions, the quiet terms negotiated behind closed doors. Wolff asking a federal court to hand this document over is not a fishing expedition. It is a direct challenge aimed at the protected core of Melania's carefully managed privacy. And the fact that he is doing it as part of a discovery motion tells you that he is fighting to win, not fighting to settle. This leads directly into the most strategically significant sentence that came out of Wolff's mouth during his statement. A sentence that fundamentally rewires who holds the power in this confrontation. Wolff stated plainly that this lawsuit was not initiated by Melania Trump or by her husband, but was initiated by his side, and therefore his side is in control of what happens to it. To appreciate the significance contained in that statement, you need to understand the deeply ingrained pattern of how Melania Trump has handled every single legal threat in her history. In every previous battle with the media, with publishers, with online commentators, with political opponents, the script has been identical. Melania's team identifies a target. Melania's team deploys a crushing volume of legal correspondence and threatening signals. The target, overwhelmed and outgunned, either folds, retracts, apologizes, pays a settlement, or simply disappears from the conversation. Throughout the entire process, the lever of control is always in Melania's hands. She decides when the threatening letter goes out. She decides when the terms of surrender are acceptable. She decides when the fight is over. The Daily Mail felt that lever. The Daily Beast felt it. HarperCollins UK felt it. James Carville felt it. The list of people who have been on the receiving end of that predictable machine is long. And the machine has never failed because the targets always calculated that the cost of fighting was higher than the cost of capitulating. Michael Wolff has broken that machine. By filing first, by being the plaintiff rather than the defendant, Wolff has seized the lever of control and refuses to let go. He decides whether this case continues. He decides what discovery requests are placed in front of the judge. He decides, with the full backing of a massive crowdfunding operation, that the financial intimidation that usually breaks a journalist's resolve will not work here because tens of thousands of individual contributors are paying the legal bills. The financial asymmetry that Melania's lawyers have relied on for decades to exhaust their targets has been neutralized by a public that is actively financing the fight. Every time Melania's high-priced legal team files a motion to delay, to transfer venue, to dismiss, Wolff's legal fund sends the bill to the crowd and the crowd pays it. The weapon of financial exhaustion that has silenced everyone from British tabloids to American bloggers is simply not working against Wolff's operation. He does not need deeper pockets than the Trump family. He just needs enough people willing to contribute to keep the litigation going, and he has them in significant numbers. The trap that Melania finds herself in is compounded by a reality that her previous targets never had to face. She cannot settle her way out of this. In every prior legal confrontation, the exit door was always available. A settlement would be negotiated. Terms would be agreed upon. A statement of regret would be drafted, and Melania could walk away with her reputation nominally intact and the threatening documents buried under a confidentiality clause. Wolff has publicly announced that he has no interest in walking through that door. He is not chasing Melania's money, and he is not seeking a carefully worded apology designed to preserve her dignity. He is chasing the truth. He is chasing the discovery. He is chasing the specific moment when Melania Trump and her friends and associates are sitting in a room with a court reporter, their hands raised, swearing to tell the truth about Jeffrey Epstein. A settlement that shuts down the case before that discovery happens is a settlement that takes away the entire prize Wolff is fighting for. And he has made it crystal clear that such a trade is unacceptable to him. The exit is blocked. She is locked inside the litigation he controls. Now we must talk about the depositions themselves, because this is where the abstract legal maneuvering crystallizes into a tangible challenge for the First Lady. Wolff explicitly stated that Melania and her circle are going to have to testify about Epstein and that the facts under oath will be much more difficult to brush aside than she managed at her press conference. To understand the difference between those two experiences, you have to recognize what a press conference actually is compared to what a deposition actually is. A press conference is theater. It is a polished, scripted, meticulously calibrated performance where the principal reads a prepared statement into a bank of cameras, says exactly what she wants to say and exactly the phrasing her communications team labored over, and then exits the stage without a single follow-up question penetrating the bubble. Melania's press conference was a controlled monologue. She was the playwright, the director, and the lead actress, and the curtain fell the moment she decided the scene was over. A deposition is the opposite of that. A deposition is a room with a court reporter whose machine records every syllable, every pause, every hesitation. A deposition is opposing counsel sitting across the table with binders full of documents, photographs, and timeline reconstructions, asking questions that are not filtered through a communications advisor, and that do not end just because the witness feels uncomfortable. In a deposition, you do not get to read a prepared statement. You do not get to walk out. You sit there, you listen to the question, and you answer it truthfully under penalty of perjury. And the questions keep coming until the lawyer on the other side says they are done. The questions Wolff's legal team will bring into that room are not going to be soft or vague or easy to dodge. They will have spent months, perhaps years by that point, preparing the evidentiary foundation. They will have the FBI files. They will have the previously released Epstein documents. They will have the Getty Images archives showing who was at which party on which night. They will have the flight logs. They will have the financial records. And they will have whatever Michael Wolff recorded during his direct interviews with Jeffrey Epstein, the recordings he has alluded to, the conversations in which Epstein allegedly talked about Melania's marriage. A skilled litigator with that much material is not going to let a witness glide through with non-answers and deflections. They are going to pin her down on every inconsistency, every gap in the timeline, every friendship and connection and social engagement that the public has never been allowed to examine. And the friends and associates dimension of this expands the perimeter of legal vulnerability exponentially. Melania does not exist in an isolated bubble. She has a circle of people who attended the same parties she attended, who were present in the rooms where Epstein was present, who know what she knew and when she knew it. Wolff's subpoena power extends to every single one of them. They cannot hide behind executive privilege. They cannot stonewall on the grounds that the First Lady would be embarrassed by their honesty. They will be placed under oath, and they will be asked the same difficult questions, and the overlapping testimony of multiple witnesses creates a framework of accountability that no single witness can easily wriggle out of. Then Wolff added a layer of psychological dimension to the legal strategy by articulating something that reframes the entire story. He said that Melania appears to be setting up a defense and that the defense reads, "Do not blame Epstein on me. Blame it on you-know-who." The implications of this reading are significant and they immediately illuminate the real strategy behind her public relations maneuvering. According to Wolff, Melania is not simply defending her own name. She is actively constructing a narrative barrier between her history and Donald Trump's history. She is drawing a line down the middle of the relationship. My Epstein connections versus his Epstein connections, my responsibility versus his. She is pointing a finger not at Epstein, but at the man sitting in the Oval Office. The man whose friendship with Epstein is documented in party photographs, in guest lists, in flight logs, in a birthday greeting that Trump reportedly sent to the predator. She stood at that podium, and in the careful language of a woman who has spent a lifetime mastering controlled public presentation, she separated herself from her husband. Wolff saw it instantly. He named it. The defenses blame him, not me. That single sentence changes the legal calculus because it means that Donald Trump and Melania Trump are no longer a unified legal front. They are potentially adversarial parties with divergent interests and potentially divergent stories about what happened and who knew what. And then Wolff put the truly significant thought into the public conversation. He declared that Melania Trump is the wild card in this White House. He invited everyone watching to imagine how Donald Trump might feel sitting in the seat of ultimate power, knowing that his fate, his political survival, his legal future was resting in the hands of a woman who just held a press conference he did not know was coming. The detail that Donald Trump was blindsided by his wife's public appearance is not a small piece of color commentary. It is evidence of a fundamental fracture in the control structure of the Trump household. Melania made a major unilateral, legally significant public move without consulting the president. She is operating on her own track. She has interests that are not identical to her husband's interests. And in a discovery process where both of them could potentially be subject to sworn testimony, their stories about Jeffrey Epstein may not align. The wild card dimension is that Melania holds the power to deeply wound her husband if she decides that her own legal preservation requires her to be honest about things he would prefer remain buried. The wife is no longer simply an asset. She is a variable, an unpredictable, untethered variable in an equation that determines the fate of a presidency. This is the hidden architecture of the entire Wolff lawsuit that has been lurking behind the procedural headlines for months. It was never a simple defamation dispute. It was never about whether one journalist used the wrong word in a passage about the First Lady. It was always about what the discovery process would unearth when the sealed world of late 1990s New York, the Palm Beach party circuit, the private islands, the modeling agency gatekeepers, and the powerful men who moved young women through those spaces was finally forced into the light of a federal courtroom. Wolff has been inside that world. He interviewed the central figures. He has the recordings. He has the documents, and his lawsuit gave him the legal mechanism to pry open the entire sealed history, to put the people who were in the rooms under oath, and to present the entire architecture of this social network as evidence in a public proceeding. The prenuptial agreement is one piece of the puzzle. The Epstein testimony is another. The friends and associates who witnessed things are another. The recorded conversations with Epstein that are sitting in Wolff's files are another. And the ultimate question that has always hung over Melania Trump's public life, the question she has spent millions of dollars and deployed legions of lawyers to ensure, was never asked in a room where she actually had to answer, is what she knew, when she knew it, and what she understood about the world she was entering when she tied her future to the man who would become president. That question is now on the docket. It is moving through the discovery phase, and the journalist she tried to silence is the one who gets to ask it. The crowdfunding dimension of this battle deserves to be recognized as the strategic masterstroke that it is. The traditional slap strategy is a game of financial attrition. You make the legal process so catastrophically expensive that the journalist or blogger or independent media figure runs out of money long before the real evidence ever sees a courtroom. The threat of financial ruin is the entire engine that makes the machine work. Defendants settle not because they are factually wrong, but because they are financially exhausted. Melania's legal team has been playing that exact playbook. They have filed motion after motion. They have contested venue. They have argued procedural technicalities. Every single one of those filings cost tens of thousands of dollars to litigate. And the assumption baked into the strategy was that eventually Wolff's resources would dry up. But Wolff is not paying for this fight out of his own bank account. He has built a financial firewall composed of tens of thousands of individual contributions from people who are specifically motivated by the spectacle of a journalist standing up to the full legal force of the Trump family and refusing to back down. Every time Melania's lawyers increase the cost, Wolff's fundraising base matches it. The weapon of financial devastation has been disarmed, and what remains is a pure legal fight on the merits, which is precisely the kind of fight that a journalist sitting on a mountain of recorded interviews is best positioned to win. The settlement option that Melania's previous targets fell back on has also been dismantled. Normally, when someone is being overwhelmed by a slap suit, the moment the plaintiff offers an off-ramp, the defendant takes it. They sign the apology. They pay the token settlement. They agree to never speak of the matter again. The case disappears into a sealed file, and the plaintiff walks away claiming victory. Melania's team is undoubtedly prepared to offer that off-ramp to Wolff. But Wolff has publicly declared that he is not taking it. He is not interested in a confidential payout. He is not interested in an apology that gives Melania the final word. He wants the discovery. He wants the depositions. He wants the public record to reflect the answers that are extracted under oath. A settlement that prevents that from happening is worthless to him, which means Melania is facing something she has never faced before, a target who cannot be bought off, intimidated out, or exhausted into submission. The friends and associates who are about to be pulled into this legal matter are likely very concerned right now. The First Lady's social circle is not composed of random strangers who know nothing. It is composed of people who were physically present at gatherings where Epstein was also present. They witnessed conversations. They observed interactions. They were part of an ecosystem. And now they are facing the reality of being deposed by lawyers who have spent months reconstructing that ecosystem with forensic precision. These witnesses do not have the luxury of silence. They have to sit in the chair, raise their right hand, and answer the questions. And the questions are going to be granular, specific, and grounded in documentary evidence that makes dishonesty a criminal act. The circle of people who know the truth about Melania's history with Epstein might be small, but it is not imaginary, and Wolff's team is going to work through it systematically until every person who was in the room has been heard from. The psychological dimension of the wildcard statement cannot be overstated. Donald Trump has spent his entire career obsessing over loyalty and control. He demands absolute fidelity from everyone in his orbit. The idea that his own wife, the person legally and financially intertwined with him for decades, might hold the power to damage him through sworn testimony is the kind of vulnerability that would concern anyone. The fact that she is setting up a defense that explicitly redirects blame onto him means she is thinking about her own survival, not his. The marriage, whatever it is behind closed doors, is now an adversarial legal calculation as well as a personal relationship. The prenuptial agreement that Wolff is seeking to unseal could, if it becomes public, reveal the precise financial terms that would govern a divorce, adding yet another layer of instability to an already volatile dynamic. The domestic life of the president is entangled with the legal discovery process in a way that no White House has ever experienced. This is the moment the legal trap closes. Melania Trump built her entire existence on the assumption that every story could be managed with enough money, enough lawyers, and enough intimidating legal correspondence. That assumption has held true for decades. The Daily Mail folded. HarperCollins backed down. The Daily Beast retracted. The machine worked because the targets calculated that resistance was more expensive than surrender and that the truth was less valuable than peace. Michael Wolff is the first target who calculated differently. He filed first. He seized the procedural initiative. He neutralized the financial weapon with public fundraising. He blocked the settlement exit with his public commitment to see discovery through. He is now standing at the edge of the discovery phase with a federal court as his venue, a war chest funded by tens of thousands of supporters, and a singular objective. He wants to put Melania Trump and her circle under oath and ask them about Jeffrey Epstein. The prenuptial agreement is being sought. The depositions are being prepared. The Epstein recordings are sitting in his files. The friends are being listed as witnesses. The defense, blame it on you-know-who, has been identified and will be cross-examined. The wild card is in play. The fate of a presidency is tangled up in the answers a wife might give about the secrets she kept. And the journalist who is supposed to be silenced is the one holding the gavel.